And I'll let them tell you a little bit about their background, but they both work in this space, but I think David does more little IP, he's more on the patent and the trademarking and that kind of stuff. So what I thought we might do is have everybody come around, real quick, not to embarrass anybody, but maybe introduce your name of your company, what you guys are working on right now. And so that way we can have an idea where we might want to take this chat, so we make sure you use your time for the next hour best. Otherwise, we've got some prepared stuff for you. So if you want to go ahead and start.
Yeah, I'm Jeff Hansford. I'm actually a probation officer here in Delaware County, adult probation. But on the side, I enjoy entrepreneurship. So I have a lot of different ideas and things like that. I've been to several programs out here over the past several years. Mainly, right now, I'm starting to kind of narrow focus on products that already exist, but to utilize them in new ways.
Okay.
I'm Jack Collins. I just registered Collins Machine. I'm just starting out. I live out in the country. I've got a pole barn, a bunch of equipment, and I'm going to put a sign out that says, "Your designs, your hopes, and repair."
Great.
I'm James Hensley. I'm from Blood Art Gallery. I'm going to take abstract art and art that I've done. I'm diabetic, so I paint with my blood. I have over 600 pieces of artwork that I'm trying to make sure I get the intellectual property rights on, and songs also, over 100 songs. So I'm here to pick up tips on
Don't let us forget to talk about copyright for you then. Okay.
copyright.
My name is Mark Slusher. I have a company, Endpoint Creative. It's a little over a year old. It's a creative media and marketing company. We specialize in corporate video for business and nonprofit.
Great.
That's about 80% of what we do.
You here in town?
Here in Muncie.
Okay.
Dr. Barbara Curcio, and I am co-founder of Corporate Care Solutions, but I'm also a snowbird, and Corporate Care Solutions is located in Tucson, Arizona. And we have developed a program, an internet program, that supposedly is the most inclusive program for clients to interact with potential customers, and we don't know how to protect that.
Okay.
How long has it been going?
Since 2012.
Okay.
Yeah.
So, thank you.
I'm a minor investor in the Corporate Care Solutions and want to know how to fire it up, actually.
Okay.
My name is Tim Marza. I run a creative agency called Indiana Creatives, and we help give small businesses and intermediate businesses a professional coach as far as graphic design, web design, SEO, things like that.
Hi, I'm Emily Helms. I'm currently a freelance writer and designer, but on the side I'm working on a mobile app. And I'm here because I'd like to know how to share that idea with potential somebody who might be willing to buy it as a company, but how to protect myself while still sharing that idea.
Brian Doherty with Google Technology. I created the business about a year and a half ago, and we've started doing automation, system automation, basically fixes. The computer will do managed IT, but we have a way that it will fix the systems naturally, so the system will continue to work, so customers is the problem.
Well, I'm Peggy Sanogo with East Central ISBDC, where we help businesses start, grow, and flourish, so I need all the help I can get in those who want to protect what they're doing.
I'm Tom Steiner. I'm with TCI SBDC also, and again, I'm along with Patty looking for ways to add value to my clients.
Great.
Isn't it in your contract that you have to do that tagline?
He's a rebel.
I'm Jennifer from and excited that we have you guys here today to provide this information to our members and the community. And so any information is great information. Thank you.
And I'm Rick Yester. I'm the author of Muncie at 150. That's a book of social media around. It's been a lot of times in media. I know all the legal issues involved in any kind of media, and I always need help because we develop new apps and some other media products here as we grow.
Great. All right, so now that we've heard that, do you guys just want to run with that, or?
What we did, go ahead and tell them a little bit about us first.
Us together,
Yeah.
collectively. My name is David Wong. I'm a partner at Barnes & Thornburg in our Indianapolis office. A member of our intellectual property department. I'm the chair of the firm's Internet Technology Group. My practice focuses mainly on what we call soft IP. This is the trademark or branding side of things, copyright or protecting creative works, and a lot of internet law, dealing with mobile apps, dealing with online services, dealing with social media, all of the above, all those issues that come along with those sorts of things.
I've got a similar practice to David. I'm at Ice Miller in our Indianapolis office. I've been with them for about 15 years now as a lawyer. So I work with a lot of startup and as well as established companies. Some of the companies I deal with, a lot of them are in the software space. Some of them also in the mobile app space. Some of the medical application space, so that's kind of interesting to do that. But I help the startup companies really with capital raising. Well, we don't find the capital, we work on these deals, okay? So we're in a position to be able to guide companies on where they should go to look for money. It's not always successful, but to the extent they got a good idea and good people running the company, usually there can be a bit of a marriage there. We also help companies with just basic formation with the patent protection that they're going to need, and try to set that out on a timeline so that we don't bankrupt the company right out of the gate. It can be expensive, these matters, and I think David will attest that it makes sense to do things sensibly when you're on a limited budget, and to do it in a fashion where you roll it out over time. There are some things that can't wait, but there are other things that can wait until a later day. So anyway, with that, I want to maybe start out with some questions from the audience. I know we've got a few people that are in the copyright space. If any of those folks wanted to ask any questions that are lingering on their mind.
How do you copyright art?
Yeah. You naturally have copyright protection in art. Same thing with writings and things like that. But when you register your work with the Copyright Office, it gives you some better rights, okay? And what I would do is I would go to copyright.gov and learn that. That's a way to do it without a lawyer. A lot of our clients need a little bit of coaching up front for us to help them with the forms and how to fill them out and stuff like that. You don't have to get a registration. If you just put your little Circle C, your name or the company name if you're operating as a company, and then the year, that kind of gives people the idea that you've got a formal bit of protection that you're trying to assert. It's not necessary to do that. You'll still have the rights that a copyright owner has automatically. Didn't used to be that way.
Is that the same as songs?
So copyright protects creative works, whether it's text, audio, visual, software, and you get under U.S. law, you get a level of protection at creation. So even if you never went to the Copyright Office, even if you never secured a registration, and someone were to infringe your copyright, they made non-authorized reproduction, for example, you could enjoin them from doing that, and you can see actual damages. So let's say they make $1 million off of the infringement. Perhaps you can go after them and get $1 million, even without that registration. But as Dustin said, the registration process, it's fairly simple. It's like, I think $35 or $45 a registration. It's a really low fee. You're working with librarians, not attorneys when you do it, so they're very easy to talk to. And once you have that registration, now you have these heightened rights, and one of the things you could get is what's called statutory damages. So you don't even have to prove your damages necessarily. You can elect for statutory damages, which is up to $30,000 per infringement plus attorney's fees. If it's willful infringement, like somebody knows, like it's pulling your stuff and knows they're infringing it, it's up to $150,000 per infringement plus attorney's fees.
The biggest time we trip it, sorry.
No, go ahead. No.
The biggest time we trip into this stuff, which is our normal company clients, is when somebody on their web design team, web designer, right? Has borrowed an image from someplace on the internet.
Yeah, don't do that.
And you think about it sometimes because it's so easy just to, right click, copy, paste, whatever. And, you don't think about it, but then all of a sudden you get a phone call from some attorney in Hawaii, real world story, who represents some photographer also in Hawaii whose photo got ripped off and published. And, they're trying to assert $10,000 or $15,000 or $25,000 worth of damages. And you're just like, what justifies this? Well, that's their asking price. Yikes. They might not win that, but that's what they're asserting, that's what they're willing to settle for. And oh, by the way, it would cost you about $10,000 or $15,000 to defend that case in federal court. So, anyway.
Do you have something like that for apps?
So mobile software is protectable under copyright law. Again, you have protection at the creation of that software once it's entered into the computer. One caveat with software and mobile apps is if you're not creating the software yourself, you're not the author of it, you're hiring out a contractor, somebody else other than a full-time employee, that almost certainly they own the copyright to that software. And as part of your agreement with that app provider, you need to have some special language in there, or I recommend if you can make it work, assigning the copyrights of that software to you, because you will want to own that software, because at some point when you're ready for your acquisition and somebody wants to buy your company for $50 million, they're going to say, okay, prove to me you own that software, that mobile app, and you're going to say, actually, that guy that created this thing for me 10 years ago owns it, and that's going to be a huge problem.
And we run into that constantly. People in the beginning stages of their organization or their beta version or whatever, they didn't have their agreements buttoned up. And then what we're doing is we're looking back on the past 7 years with the development saying, how much of the original stuff, even conceptually, is still there? And you can't get clean answers. So it's always a risk. It's not that we can't work around that. It's not fatal, but it can be a big problem like David is suggesting.
But what if it were our ideas,
Yeah.
but he puts it
Yeah,
in?
so now you're between the arena of patents, which covers your ideas, and copyright, which covers the specific way you lay down the code, okay? And with patents, if you're already out there in the marketplace, you need to get a patent application on file within a year.
Within a year?
Yeah.
Within a year of the application
Yes.
going live?
That's right. Otherwise, you lose your right to get a patent.
On the
Now-
patent side.
On
Yeah.
patents?
On the innovation. So patents
And
protect.
you recommend it? You recommend getting a patent?
It
I
depends.
do when you can, so it's expensive, right? Let's just use rough numbers. $10,000 or $20,000 for you to get a patent application on file. Sure, yeah, it doesn't have to be quite that expensive. I mean, I've done them for 2 or 3. I've done them for 30 or 40. So, it's just giving you kind of rough numbers. And there's a way to kind of stretch out the spend as best we can. Like, we've got clients who come in all the time and they've got the basics developed. And they say, okay, we're getting ready to go live with this. What do you recommend? I say, okay, give me all kinds of screenshots. You draft up a narrative. Tell me how it works. Tell me how from a user perspective. Tell me from a back office perspective, from a corporate client perspective, all the different angles. Tell me how things go. And they give me kind of flow charts and narrative discussion. We package all that stuff up, staple it, not really, file it electronically is what we do. And then that's the provisional application.
From
That's-
patent, you have to go through a lawyer? As
No.
opposed to a copyright?
No, but man, I'll tell you what, I wouldn't recommend it to anybody trying to do this solo. It's better than not doing it at all, but by about that much. I overstated it a little bit. I mean, this is not an arena for the untrained to be delving into. Then within a year, you gotta file your real patent application, that's when stuff gets expensive. So that's to really start lining up investors and talking with angel investors and folks like that out of the gate.
And maybe we should back up just a little bit and talk about the different types of IP protection. So I'll let Dustin talk on the patent side of things. So copyright protects the expression of creative works, the creation. So again, software, the actual code that the person chooses to use. You talk about ideas versus expressions. Those are two different things that may be protectable under two different doctrines of IP. So copyright protects art, graphic design, logos, all those sorts of things, software. There's also what we call trademarks. I do a lot of trademark work. Trademarks protect brand names, logos, anything that identifies is a business identifier, a source of a product or service. So Colab is a brand name, it's a trademark, it needs to be protected, and you can seek registration for that. So we have copyrights, trademarks, and then the other big one, what we call the big three in IP, is patents, and Dustin can explain that better than I
Yeah,
can.
patents really, there are several different types of patents, but the most important one to most industries in this day and age are what we call utility patents, and they cover how something actually functions, okay? Now, it can cover the apparatus that you're dealing with, so if you have a machine that you've created that, you know, extrudes things that look like Twizzlers, and they're actually dog treats, like we're not patent down. You can cover the machine, or you can cover a process, what we sometimes call a method, okay? So a method of doing business in a particular way, or a method of carrying out something, like if we want to deliver a secure text between a doctor and a patient, for example, like one of our clients, Diagnose, does. There are several workflows and steps that go on between, you know, securing the information that needs to be texted to putting it through an engine that actually encrypts it, et cetera, and then delivers it in a text format on the other end. That's the type of process that we can sometimes pack a patent application around. So that's just an example of what we can do. You get patent protection on more things than you might ever dream. And I heard you say that you're taking kind of existing products and tweaking them for new uses and things like that. That's sometimes the area of patent as well. It doesn't have to be brand spanking new and pioneering. It can just be a new use of something that's existed, or a new twist on something that's come before.
So when you're protecting whatever your product or service is, whether it's a software app, whether it's artwork, whether it's something on social media, there may be multiple different types of IP that you find. For example, you take the mobile app, right? It has a name. That's something that you may want to look at protecting under trademark law. You've got software, you've got visual designs, maybe you've got graphics up on there. That's probably protected under copyright. To the extent it's innovative, there's something new that's not been done before, that's potentially protected under patent. And so you may have a bundle of rights and different types of IP that can all apply and protect in different ways, depending on your product or service.
Well, can you clarify, you brought up social media, clarify what is and isn't copyrighted versus public domain, and what the law specifically says about social media in the state?
Sure. And I'm guessing the angle you're taking this is when you go to social media, what
No, I'm
can you
just
borrow?
asking your opinion.
Okay. Give me a little bit more clarification on what you're looking for.
Again, give me an opinion on what, if anything, is copyrighted on social media.
Yeah. Okay. So the default laws of copyright are that the original author, the author of the original work, it has the exclusive right to reproduce, distribute, publicly perform or display, or make derivatives, which are edits of things. So we have to start with that premise. That's the base law.
Both on content and image.
On anything that's creative, so words, images, all those sorts of photographs. Then you can look for exceptions to those rules. So there's a litany of enumerated exceptions to that rule. One that we often hear about, especially in the social media context, is fair use. When is it fair, for example, if somebody posts something online, that you can take it and share it with others in an email, for example?
And by the way, there's an entire law school class in some law schools that will probe into fair use. So to be fair to David, your question's a pretty big one.
Yeah.
But the law isn't very much at all, especially in the Midwest. Or maybe you can tell us what the law is in social media.
Again, if we could take some examples. So I represent a lot of social media companies, and so we're consistently getting demand letters or complaints, you know, you
Right.
have people are infringing our rights on the thing. Again, you start from this base position that if you reproduce something, even if it's available on social media, and it's unauthorized by the copyright owner, that implicates the copyright owner's rights. And then we start digging into these exceptions and say, well, what is it fair use? So fair use is the grayest in, this is a legal term, squishiest area of IP there is.
Thank you.
You got,
There's also, I mean, the DMCA, which has a safe harbor provision for companies, like David's representing, which have platforms to post things. So if I'm a platform, like, let's
Is it
take.
Facebook? Is that?
Yeah, it's Facebook. Facebook's a great example. If one of the Facebook users, you, goes on to Facebook and posts a bunch of infringing content, other people's pictures, other people's writings and stuff like that, then if Facebook follows, and they do, certain posting requirements to notify copyright owners how they go about asking Facebook to take down their stuff that's been infringed, then they, Facebook, are out of the woods. They will not have any kind of liability because of the safe harbor that the government has provided them in the statute. So that's another way that you might have some appearance of infringement on the internet, but until the actual platform, Facebook in this case, is notified, they don't really have any concern because they've got, you know, unless they've got red flag knowledge, which is another exception, not like other things. But we're kind of deep in the weeds, I think, on this one topic. But, you know, surely we'll be here after the program's over, so if we want to probe that any further.
Well, that's the issue. It's not necessarily the user, but it's the platform, whether it's Facebook, YouTube, Twitter.
Yeah, it can be. Again, most of those companies are fairly sophisticated and they're following the safe harbor provisions. So they're going to be out of the woods, most likely, and then it's the individual user who would then be on the hook for any kind of infringement.
as long as that platform remains passive conduit, there's no way that Facebook can monitor the millions of creative works on its platform. And so the government provides a safe harbor saying, so long as they remain passive, have no knowledge of the infringement, when they receive a complaint, if they expeditiously remove that from their platform, they have no liability.
If I have somebody stop by with an idea, or something they want done, you know, they have a problem, and I design something for that, whether I make it or not, can I protect that, my design?
It depends. I'll take that one because then you can fill in.
Yeah.
It totally depends on how much you contribute, how much they contribute. Okay.
Well,
And
for
it
instance, I got a neighbor
depends
who he was a police dog, policeman, and he was wanting to make a muzzle that he could have on a leash and just go and release both the collar and the muzzle at the same time. And, you know, I come up with an idea of how to do that.
Yeah.
And,
So it was his idea, and you refined it.
Right.
Yeah, it's got a co-inventorship right there. So
Okay.
you might both be
All right.
inventors on a patent application.
Okay.
It depends on where we take what we call the claims of the patent, which is really where you define the boundaries of your rights. But like if we have a dog leash muzzle combination that has a press button that releases both, that might be as broad as I want to take the claim, or as narrow as I want to take the claim at first.
Okay.
I can start packing some details on later claims. And if you study a patent, you'll kind of know that they've got a number of different claims, and you take the structure of a device from several different angles. But anyway, long and short, yeah, I mean, it would be you and him probably both on the original patent application, and then we would decide who the inventor is based on who we're representing. So like if I'm representing you or your company, I might say, okay, you tell me what he told you, and let's figure out what you've invented. And maybe we can get you your own patent around that. It's a little tenuous to do that sometimes. Sometimes it's better just to be a little bit more thoughtful about the partnership, if you will, and just have a joint effort that you are both pursuing patent protection, split the bill, right? That kind of stuff. There was a
Yeah, I have two quick questions here. One about logo design. I have somebody design a logo for me. I heard creative copywriting and things like that, and then I started thinking, I don't know that there was even a receipt that was passed between when I got this logo design. And I was just curious, is that a potential issue, I guess, in that?
Yeah.
Go ahead and give you the second question. Second question is, when should I start trademarking, at what point in my business?
So I'm looking at your logo right now, and if everybody can see what we're talking about, to say if something's in line. I would say there's potentially 2 levels of protection there. One is trademark, it's your business identifier. When people see that or hear that name, you want them to think exclusively of you. And so if somebody in Illinois starts a similar business with a similar name, you may want to be able to prevent that from happening. So that's trademark law. The other component of this, because there's some creative elements to the actual design, that it may have some level of copyright protection as well. Certainly the more distinctive your logos get, the more likely you can protect it under copyright. So we're talking about 2 different levels of protection. If you had a contractor do this, and this applies to everybody, anytime you have a contractor do something for you or your company, you should be thinking about IP and how you're getting it moved into the right place to you and not to them. What I would suggest you do is have them assign the copyright to you. Go back to them. It can be as simple as, it needs to be written, it needs to be signed by them, but it should say something like, contractor hereby assigns to Hula Technology the copyrights to this logo signed by them.
How do you usually handle the name? Like the name, so like Hula?
Hula.
Yeah. So would you do a trademark, because it's not really the designer that's developing the trademark protection.
Right.
Would you still get a trademark protection in that case?
So, no, if someone else, like if you have a marketing firm or somebody that helped you choose the name Hula Technology, it really has no rights to it until you start using it in connection with a product or service. So really, I don't think there's any need to have them assign that to you. You are the one who initiates the protection by using it in commerce, even if somebody else comes to your name. And then what I would say is, it depends on what your aspirations are. If you want to protect your name outside of the state, for example, the best way to do that is to seek federal registration of your trademark. If you want to, as someday, be able to stop somebody in Illinois or Ohio or California or New York from adopting Hula Technology, because you're going to move into those spaces at some point in time, at least that's the hope, you can bookmark your place and time by filing that federal trademark application, which gives you presumptive rights against anyone else in the country that adopts a confusingly similar name in your space. Yes?
So if I want to start Hula Technologies in Ohio, how do I search to see if he already has it?
Yeah, well, there's a couple different ways. And we do this all the time in my practice, where we hire search vendors that go out and scour the federal trademark registry, 50 state trademark registries, Dun & Bradstreet's copyright databases, the internet, social media, looking for other Hulas. So when a company adopts a new name, like, am I going to infringe somebody's rights? That's what we do. We go out and we do all the searching. For smaller companies, sometimes you do the best you can, right? You can go to the USPTO, the United States Patent and Trademark Office, and do kind of a hunt and peck search. Type in Hula, see what comes up, read through the list, make sure, somebody's selling shoestrings under Hula, probably not a problem. And then you do your internet searching, kind of what we call quick and dirty or knockout searches. Just do the best you can with the resources you have. And then, again, you might at that point say, I'm not finding anything, not a huge problem. I think I'm going to go ahead and file this federal trademark application, lock my place and time. Because the longer you wait, if somebody starts using it the day after, then you're now second in line on some level.
What does something like that